I'm Paul Castle of the Castle Law Firm. In this segment, I would like to speak to you briefly about Rule 4B of the North Carolina Evidence Code, what's known as other crimes, wrongs, and acts. A clear understanding of this rule is extremely important for any practitioner of criminal law or criminal defendant because it is one of the rules subject to the greatest misuse, misapplication, even abuse, resulting in the miscarriage of justice, even in the wrongful conviction of a defendant in an extreme case. The name of the rule says it all in a way. Other crimes, wrongs, and acts. Imagine defendant K is being tried for an alleged offense resulting from incident A. Incident A he was involved in. The rule, roughly speaking, allows the prosecution to introduce evidence about an entirely different incident. Incident B, Mr. K was involved in. So the question is, why is the prosecution allowed to introduce evidence about an incident entirely different than the incident Mr. K is being tried for? That's what makes this rule controversial, problematic, even fascinating. Let's look at the text of the rule. The rule says, evidence of other crimes and wrongs and acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake, entrapment, or accident. Imagine Mr. K is being tried for a felony assault charge resulting in incident A. Imagine Mr. K is also allegedly involved in an entirely different incident, incident B, where he assaulted somebody else. If the prosecution tried to introduce evidence about the prior assault incident about Mr. K in order to show that he's violent, so he must have acted violently in this case, incident A as well, the rule says such evidence is not admissible. But exactly the same evidence or similar evidence may be deemed admissible if it is being introduced for a legitimate purpose, such as proof of motive, opportunity, intent, or preparation. In State v. Graham, which is a 2000 Court of Appeals case, Mr. Graham initially assaulted victim C and he was going to be tried. But before he was tried for the initial assault case, he allegedly assaulted and killed the same victim, victim C. Now, when he's being tried for allegedly killing victim C, the state was allowed to introduce evidence about the initial assault case where victim C was assaulted but was not killed, because the state said the evidence of defendant's other crimes and wrongs and acts in this case show his intent, defendant's intent, Mr. Graham's intent in assaulting and killing victim C in the homicide case. The intent being preventing the victim from testifying against him in the initial assault trial. So the same evidence, if it is being introduced for one purpose, illegitimate purpose, is going to be kept out. But the same evidence can be deemed admissible if it is being introduced for a legitimate purpose. And that's what makes this rule subject to misuse and controversy. Now, who makes the determination as to proposed piece of 4B evidence being introduced for a legitimate purpose or illegitimate purpose? It is the court, it is the judge. In a pretrial setting, the judge is going to receive a proposed piece of 4B evidence, will make a determination as to whether that evidence is being introduced for a legitimate purpose, such as showing character, or for a legitimate purpose, such as proof of identity, proof of preparation, proof of motive, and so on and so forth. Now, the next question is, if the court determines that a proposed piece of 404B evidence is being introduced for a legitimate purpose, the question is the jury going to receive that piece of evidence in the same way the court would receive it? That is the jury going to say, well, now that we received evidence about the defendant's prior incident, we don't care about the defendant's character or disposition, whether it is peaceful or violent. But based on the evidence about the defendant's prior incident, now we are enlightened. Now we know what motive the defendant acted in the present case. Now we know with what purpose the defendant acted in the present case. Is that how the jury is going to perceive the proposed 404B evidence in actuality? We don't know. There is no telling. My honest answer is probably not. But what we do know is the more 404B evidence is introduced, the more damning the 404B evidence is going to be, the more likely the defendant is going to be convicted. So the natural tendency is the prosecution try to introduce more 404B evidence, and the defendant tries to keep out any 404B evidence that is being introduced. And the fight about the introduction or keeping out of 404B evidence tends to be one of the hotly contested battlegrounds in the context of a trial. Well, that's all we have for this segment, and please tune into our next segment. Thank you for watching.